by 19th of December, there should have been revival of the assembly, because the assembly was not dissolved. See the political motives and the illegality in the whole process. This can't go beyond 6 months, beyond 19th December. So he has to revive the assembly. There's no dissolution. So on 19th December, he dissolves the assembly. On 21st November, he dissolves the assembly. Now, dissolution can't take place without the aid and advice of Council of Ministers. Section 53 of the Jammu and Kashmir Constitution. Section 36, 38 and 92 are the only exceptions under the Jammu and Kashmir Constitution. I mentioned it earlier also, where the governor can act on his own. But 53 is not. 35, 38 and 92. 30. So, Malads, he could not have dissolved. And after dissolution, 356 can't be imposed. After Muller's dissolution, Article 356 cannot be imposed. These are Constitution Bench judgments of this court. Now, your lordships asked me the question last time also, you've been asking other council also, why did you not challenge it? Number we could not challenge as far as the governor's order of 20th June is concerned, because under the Constitution of Jammu and Kashmir, you had to put the government back in place within 6 months. Where was the occasion to challenge it? Council of Ministers would have been back in place.
What would happen if there's no conceivable government formation possible?
Well, he can't do it. That's a point.
Mr. Sibal, that's little saying that because it was tenure or 6 months, I can't challenge this wrong.
No, I said I haven't challenged it.
You can't challenge it.
Not, I'm not, I can't. When I said I can't, I mean we knew, Malas, that
you can certainly challenge it, and you do, people do challenge it.
But Malas, the government was to come back in place, Malas, was to be put back in place.
That may be little.
The government was to be put back in place within 6 months, Malas.
My only question is how, if in 6 months no government is feasible, possible, then necessity would require a resolution, would it not? What
I'm
would
sorry?
happen? Let us say there is no government possible. Then whom will he put back in? What kind of governor?
So, Malas, what you do is you impose 356, then you dissolve. With the process of under 356, Malas, I've explained it last time also, that you keep the assembly under suspended animation. You see if you can form a government or not, because 356 is a temporary provision to restore democracy. If you find that there is no possibility, after imposing 356, you dissolve and hold elections. That's the process.
So then the dissolution should have taken place under the rubric of Article 356.
That's correct. That's correct. And that's a Constitution Bench judgment. I'll show that to your lordship straight away. Just keep that judgment. Document volume 19. Sorry, case law compilation. PDF 232. This is the Constitution Bench judgment in the matter of special reference 1 of 2000.
Compilation.
Compilation 19, volume 19, case law compilation 19. And I've been saying this from day one. This was the political process. The intent was entirely political and the means were entirely unconstitutional. Yeah. May I read it, Malas? Dissolution brings a legislative body to an end. It essentially terminates the life of such body and is followed by constitution of a new body, legislative assembly or house of a people, as the case may be. Prorogation, on the other hand, relates to termination of a session and thus precludes another session, unless it coincides with the end of the legislative term. The basic difference is that prorogation, unlike dissolution, does not affect the legislative body's life, which may continue from session to session until brought to an end by dissolution. Dissolution draws the final curtain upon the House. Once the House is dissolved, it becomes irrevocable. There is no power to recall the order of dissolution and or revive the previous house. Consequently, effect of dissolution is absolute and irrevocable. It has been described by some learned authors that dissolution passes a sponge over the parliamentary slate. The effect of dissolution is in essence termination of the current business of the legislative body. In its sittings and sessions, there is cessation of chain of succession, sittings for a dissolved legislative body, and there cannot be any next session or its first sitting. With the election of the legislative body, a new chapter comes into operation. Till that is done, the sine qua non of responsible government accountability is non-existent. Consequently, the time dissolution is non-existent. Stipulation is non-existent. Any other interpretation would render use of the word "its" in relation to the last sitting of one session, the first sitting in the next session without dissolution. Right, Melissa? Now 319. So far as the applicability of 356 is concerned, though in the order of election commission has specifically dealt with the possibility of applying that situation, in the written submissions and the arguments made before this court, the view was given a go by. And in our view, rightly, mere non-compliance with Article 174, so far as the time period is concerned, does not automatically bring in Article 356. It is made clear that an order of the election commissioner is the foundation and not what is stated subsequently by way of an affidavit or submissions to clarify. But in view of the concession, which according to us is well-founded, we need not go into the question in detail. It is submitted that by some of the learned counsel that the election commission's order otherwise makes out a case of applying 356 when the requirement of 174 is not met. In Thiru Rajagopal versus Karnanidhi, a constitution bench of this court said, Article 356 of the Constitution makes provisions in the case of failure of constitutional machinery in the state, but when the assembly is dissolved, there is no failure of the constitutional machinery within 356. Because the governor was ruling for 6 months, where is the question of 356? So you do it this way, tell the governor, whereas he sort of puts it in suspended animation, less the 6 months almost part when the government, when the two parties say that, look, we are ready to form the government, but that's not proved, Malats. Then on 19th December, President rule is imposed after the assembly is dissolved on 21st of November. Couldn't be done. Then if that's bad, and that has to be decided by this court, because that's the basis of 202, 272 and 273. So whether we challenge it or not, that's the very basis.
That this can happen, right? Because the section 92 power is sui generis.
Yes.
Normally, even when
he has to act on the aid and advice. No.
Normally, when an assembly is placed under suspended animation, as we call it, that's also an exercise of the 356 power.
Yes. That's on the recommendation of the governor.
That's on the recommendation of the governor.
The governor, that it can't be carried on in accordance with the provisions of the Constitution. Then 356 is, well, that's what happened.
And the recommendation of the governor again is on aid and advice, or that would not be on aid and advice?
No, it never is.
It will never be on aid.
It never is.
So
No question doesn't arise.
So we are just wondering, according to you, the dissolution of the assembly on 19th of December is wrong, 19th of November is wrong, because it had to be by
November. Yeah,
25th of November is wrong.
21st November, yeah.
Because there had to be aid and advice. There was no aid and advice.
Apart from that, Malads, where was the occasion for 356 at all? Because he was running the administration. Malads, he's running the administration. There cannot be a constitutional failure. That happens only when the government cannot run in accordance with the provisions of the Constitution.
But therefore, no, but we're just testing it like this. Suppose the governor's dissolution is, according to you, incorrect. The consequence would be that at the end of 6 months, the legislative assembly has to be restored?
No.
The suspension would come to an end after
6 months?
Yes. Then the Council of Ministers have to be...
Council of Ministers has to be formed?
Correct.
Now, taking your argument to the logical conclusion that, look, the dissolution was wrong and the governor had to necessarily at the end of 6 months
Before.
restore, before 6 months, restore the legislative assembly,
Yeah.
lift the suspended animation,
Yes.
invite a government. In which case, can the government of India not have then exercised, the president not have exercised the power under 350?
Correct. So then he would have had to make a recommendation that this is not, they are not functioning in accordance with the provisions of the constitution because the governor was ruling for 6 months. Where is the occasion, Malas, for him to at that time exercise that power?
But if no state government is possible, nobody is agreeing to combine together.
But that's fine, Malas,
Keep the facts aside.
in which you impose 356. Don't dissolve it. Well, that's the whole problem. You impose 356.
And keep the assembly in suspended animation.
That's always the case. I'll give you several notifications. I don't have the time. That's always the case. What you do is you keep the assembly under suspended animation. You try and, you have to restore democracy. So at some stage you feel that now it's time to hold elections. You dissolve the assembly and announce elections. That's the process followed in every 356 proclamation. You never dissolve the assembly immediately, but then you have to hold elections. Well, the democratic process can't be stultified, can't be used in this fashion. Because this was, as I said, this is a political decision. It has nothing to do with the constitution. I've been saying that from day one, Malas. These are political decisions. Even 272, 273 is political. Maybe